Let's speak to Chris Daw KC, barrister, writer and broadcaster. And Chris, of course, a regular with us on the programme. We've talked about this quite a lot of late, Chris. Just a point, if you would, on that, the technicalities of this. Talk us through what I can understand. I can get what a defence mitigation would be. I think we all understand that. Prosecution words at that point, what would they be saying? Would they be imploring the judge for the most harsh kind of sentence? Is that how it works?
Not necessarily the most harsh kind of sentence, but the prosecution absolutely will go through the sentencing guideline, and there is a sentencing guideline for murder, as you would expect, where different murders in different situations and with different behaviour by the defendant result in a longer minimum term before someone can apply for parole. And in the case of murder with a firearm, the minimum term that the judge is generally required to start with is 30 years, so a minimum of 30 years in prison before parole. As your previous contributor, Norman Brennan, suggested, I think just before the break, in this case, my belief is the judge is likely to go higher than 30 years as a minimum term. Before Cashman, who's currently 34, could even apply for parole. And if it were anything like 35 or 40 years, of course, he would be into his 70s before he could even apply for parole. But the prosecution absolutely try and help the judge with the correct approach to take in law, how the case fits in with the sentencing guidelines. And the defence's job is pretty much the same in a case like this, where the sentence is automatic. It's automatically life. There's no doubt about that. The defence's job is to try and persuade the judge that a lower starting point than the one perhaps that might be the highest possible starting point should be applied. So the defence will probably in this case be arguing that it should be 30 years, which is the starting point. The prosecution will be giving reasons why it could be higher. Yeah, just give us a taste of that, if you would, Chris, because you have stood there, you have given these arguments to judges. As a defence lawyer, you've attempted to, and successfully created those arguments. I get that's what our justice system is. It would be a bit weird if it was anything but that, even if we don't always like the cut of the jib of the argument on a particular case. But how do you mitigate on a case such as this when you can't talk about previous good character? There's really no... there's no doubt about guilt. There's no doubt that there's a life sentence. What the heck can a lawyer advance to a judge? By the way, a judge knows all this stuff anyway. So what is the point of that process? Well, the point of mitigation is very important because you have sides to case. You have two sides arguing whether someone's guilty or not guilty, as you know. But when someone's been convicted, those two sides' jobs remain different. The prosecution's job is to achieve what it sees as being the most just outcome on behalf of society. And in a case like this, that would be a very long sentence. The defence's job is to argue, and it's quite a technical argument, but you believe it or not, there's a load of tick boxes. If a case involves more than two victims and a knife and various other permutations, it all comes down to whether the judge fits the case into one particular box in the sentencing framework, and the defence's job is to try and persuade the judge to come down a bit, and the prosecutor's job is to talk it up a bit. There's nothing wrong with that, because that means everything is out in the open. The judge has heard all the arguments, and as we'll hear shortly this afternoon, I think the judge will come to a very wise decision. And I suspect most people, when they hear the way the judge explains the sentence, will completely understand why it was passed.
I don't know whether you've ever had to make a mitigating case to Mrs. Justice Yip, Chris, but I would imagine whatever she is thinking, she probably spent the best part of last night and many days before compiling and doing some very officious and very intelligent and thorough, as most judges are, research and diligence into all of this. And written down a number there somewhere. I don't want to cheapen this in any way, but if she's written that number down, is it really likely that anything a defence lawyer is going to say is going to change that?
Yeah, oh, absolutely, and it happens all the time, but it can happen in one of two directions. I mean, a judge can listen to the defence and actually come up with a point to argue against what the defence barrister is saying and saying, do you know what, now I think about it, perhaps it's even worse than I thought. So, that's obviously our worst nightmare as a defence lawyer, is that you go into court and you mitigate, and the judge maybe has a number of paper which ends up bigger than the number when she actually passes the sentence. But this particular judge is a High Court judge, incredibly experienced, and all of these frameworks and and sentencing guidelines and all of the issues that judges have to take into account, she almost won't have had to research. This is bread and butter for a High Court judge. I mean, sadly, there are more than one murder a year in this country, and people have to be sentenced for murder on a very regular basis these days. And you know, perhaps the bigger question around this case, which we should be asking ourselves, is why are we having these armed gun wars amongst drug dealers on our streets that lead to the innocent victims dying at the age of 8 or 9 years of age? Because to me, that's a more important question than the exact sentence in this one case. We need to try and reduce this sort of thing across our society, and we're not doing anything about that at the moment.
Just on that point of televising these kind of proceedings, this is relatively new in England. It's been in Scotland for some time, but we know that when we watch what happens in the United States, we saw it recently, Gwyneth Paltrow, it was a civil case, but nonetheless, there it was, Gwyneth Paltrow, big high-profile stuff, O.J. Simpson and many, many others we can name. And we watch them with interest, and other than the jury, which you don't even see in the American cases, I think I'm right in saying, and rightly so, we all get that, but you would like to see much more of this, much more transparency in the courtroom.
Yeah, absolutely. And I think it's a shame that I'm having to explain to you the sorts of things that barristers say in mitigation, because we can't just listen to what the barrister is saying to the judge. We should be able to listen to everything the prosecutor says, everything the defence barrister says, and then we should be able to hear what the judge's sentence is, because then people can judge it for themselves. And as you say, in America, in fact, in some cases, they do show the jury as it happens, although I don't really agree with that. But when someone's been convicted, the trial's over. The jury's got no more role in the process once someone's been convicted. My view is that we, the public, and you, the public, who don't get the chance to go and see this day to day, should have everything on television, everything open to the public scrutiny, and then maybe we'd have a bit more trust in our justice system because we'd actually see how it works.
What would be the reason that this particular part wouldn't be televised? Is there anything that would be, given that everything we know so far, we're about to see or hear, we won't see the perpetrator in there, we won't see Cashman. We'll only see the judge. Given that we know quite a lot, what might be in these mitigating circumstances that could be, well, it's not even prejudicial, of course, because the case is over.
Yeah, it's not about being prejudicial. It's just that the rule that's been introduced to allow the televisation of sentences only allows the judge's sentencing remarks. So it doesn't allow any of the other stuff to be televised under the rules. And the reason is that they wanted to take a very small step towards televising criminal proceedings. We've had appeals televised for some years. We have now got a part of the trial process, just the sentencing process, and it's little baby steps towards more openness, one hopes. But the reason we don't see it is because it's not allowed. I think that's wrong. I think we should be allowed to see everything that happens. Once the jury has returned its verdict, there's no risk of prejudicing the jury. Let us see everything that happens in our name.
Chris, thank you. Chris Daw KC, broadcaster, barrister, writer, with some really interesting meat on the bones of the kind of legal ramifications around this.